Hey, Heather, how are you?
Hey, good. What about you?
All right. Feel free to stop me anytime if you have any questions.
Sure. Am I the only one online?
I think so. I've got Nagendra and Deborah probably joining us online.
Okay,
But I've asked, some other people have asked me to record this, so
sure.
recording it too. All right. Do you have a copy of the MR GCAR contract on you, Heather?
Let me see. Did you send that
Let me
to our
send some-
email on the
right.
moment?
Yeah.
Did you send the email to us, or we need to log into the the zip form?
I can send it to you.
Okay, thank you.
Thank you so much.
Thank you very much.
Okay.
She's got chickens.
Oh, really?
Lisa. She has a couple of ducks too. She's got some different colored eggs.
Oh, okay. They're not cooked, right?
No.
Oh, okay. Oh, I'll take a couple or one, whatever.
Wow.
I love fresh eggs.
I don't know that I've had a fresh egg.
Not
They taste
fresh, like
different.
freshly.
I know, but do
But-
they taste different?
The yolk is like a different color.
It tastes a lot better.
Yeah, they're better.
The ones you get in the store, they're sitting on the shelves for
Yes.
weeks and weeks and weeks before you actually.
I used to
them.
buy them from someone. and
They're a lot
said,
fresher.
"You don't even you can cook them out. Like, you don't wash them or anything, just leave them, you can leave them out. You don't have to
Oh.
refrigerate them.
That's interesting.
Because I think what they do, it has like a film, but then the stores, I think they remove all of that and they wash it.
Yeah.
and then- That's why my grandmother in the Dominican Republic, they would have their eggs out. I'm like, that's weird.
I thought it was weird to
That's
her
why.
out on the counter.
Yeah,
Yeah, as long
My
as you
son
don't clean
bought
them.
home like a dozen from a farm the other day.
yeah.
I'm off to, so I'm not taking them off.
As long as you don't do what?
As long as you don't wash them, you can keep them out of the fridge.
Oh, really?
Mm-hmm.
Oh.
Yeah,
You can wipe them off, but there's
yeah.
called like a bloom. I literally just read about it on
Yeah, yeah.
Facebook. But once you remove that, then it allows like bacteria and stuff to get in.
Yeah, and then there's the trick where you drop it in a glass of water to find out if they're still
Yeah.
good.
Yeah,
So
if it floats.
it's not good.
Oh, really?
Yeah.
Never done that. I've done that before.
So if you're like, oh, these are questionable, you just put them in a cup of water, and if they actually float, then throw
Throw
them
it
out.
away.
But if they're up a little bit, then they're still good. If they're floating, then that's not good.
Probably eaten a
How
lot
much
of
I
it.
haven't seen that.
Yeah.
We used to have chickens too, and we
Really?
also had a rooster, so during like the mating season, whenever we would collect the eggs, we would have to put a flashlight under
To
each
see if
egg to
there's
make sure it
babies.
wasn't a baby.
I had ducks and we had babies. Yeah.
Mhm.
Yeah, you wouldn't
So we would
want
put them back.
to make that accident.
Yeah.
So
Yeah.
the flashlight, you can
Mhm.
tell.
Yeah, like you'll see the veins and stuff if you're like in a darker room. You just put a flashlight under and you'll see like the little chicks in there.
That's
Good.
cool.
Yeah, they're
Handling.
I
probably
would not want to boil.
Mhm.
Yeah.
Even horrible, like
You immediately put it
traumatizing.
back. Yeah.
All right, so just give you an assessment of where we're at. So today I wanted to go over contracts. I know this comes up with you guys. You know, and again, most of us newer to the business tend to work with buyers a lot more than sellers. So it's always important to be really kind of confident around the contract and understand what it says and sometimes what it doesn't say, because sometimes what it doesn't say is just as important as what it does say, because there's a reason why there are certain things that are omitted from this. And then it's always like, the more you understand it, the more you can help your client. I always try to say, like, if I can give my clients options, right? Like, here's 3 options you have. As we, 7 days into the contract, all of a sudden our options narrow. But I think as long as people understand they have options, right? they either exercise those options or let those options die or disintegrate, or don't take those options, at least they feel more in control, as opposed to sometimes what happens is it's like, oh crap, here we are, like you've got to make a decision this second, you don't, this is the only decision you can make. People don't love that. So as much as we can stay, I always talk about like 3 steps ahead of the contract, the better. So a couple of things just from a, I'll start with the G-car contract and then I'll go back to the MR. So, and for us, like, because we have 2 offices, one's on the border of Howard County, the other's on the border of Frederick and Carroll counties. We have to understand both sets of documents. You're going to get agents coming in here with MR contracts. You're going to have to write outside of Montgomery County with the MR contract. It's good to know both. So we have 2 sets of contracts. Why? Greater Capital Area Association Realtors plus DC Association of Realtors, or Montgomery County Association of Realtors, DC Association kind of combined to form GCAR. So what you'll find is that our forms work in DC, right? The GCAR forms work in DC, and DC forms work in GCAR, but outside of Montgomery County, everyone else uses MR, Maryland Realtor forms. And just so you sound smart, it's not MAR. MAR, they had a big dispute with Massachusetts Association of Realtors, and we were no longer allowed to use MAR. We are MR. Yep. So if you want to sound really smart, say MR.
Okay.
Good to know.
Yeah. So again, outside of our jurisdiction, outside of GCAR jurisdiction, everyone else uses MR. MR pretty much does 99% of the forms for each of those counties, and then each county usually has like a county specific or a city specific disclosure addendum. You know, GCAR has a lot more forms. I'm preferential to GCAR. I've sat on GCAR contracting clauses. I see how the forms are written. I know how good they are. That if all things were equal, I would use GCAR everywhere and anywhere, but it's just not possible once you get out of GCAR land to use a lot of GCAR contracts in MR land.
Why do they do that?
Just there's a little bit of, I mean, there's a little bit of territorial reasons, right? Like, yeah, I mean, people want to use the forms, and some of them, they, you know, the GCAR form doesn't work in other jurisdictions for certain reasons. It needs certain modifications to fit. And you know, a lot of people who are outside of GCAR land, GCAR is like a foreign country to them. They could care less what GCAR does. This is the way I do my forms. This is the way I've always done my forms. They never get a GCAR form that comes in. So they're just not open to using another form. And that can also create issues sometimes, because if agents aren't used to how GCAR forms are negotiated, you can sometimes run into issues with them, especially when it comes to timeframes. So we'll kind of dig into some of that. So first, starting off, I'll tell you one thing to keep in mind: whenever you see a word in the contract that is capitalized. For instance, you'll see this in the first paragraph as you go down, and you'll see like listing company. Even though listing and company should not be capitalized, it's capitalized here. Same with selling company in the top of the GCAR. Yep. Just that's like kind of it's a legal way that they're defining something. So whenever you see a word that gets capitalized that shouldn't necessarily be capitalized, like sometimes lender, like you'll see lender gets capitalized. If you see a capital lender versus a lowercase lender, it's a big distinction, because that lender has been defined somewhere. The lender is the lender who wrote the lender's letter that originally came with the contract. It's not just some other lender who maybe is in alternative financing. So that's just something just kind of as a practical note to keep in mind, right? Whenever they reference the buyer and seller, they mean the buyer and seller who's defined in this first paragraph. Got it? Okay. Couple things about paragraph 1 of the GCAR contract. You've got street address, unit, you've got lot, block description. This has a lot more information when you compare it to the MR contract. It allows you to be more specific. So for instance, if you are selling a property that has an outlot, sometimes you've got a property, sellers are selling their house, they've got an extra 1/4 acre that's just completely usable outlot, but it comes along with the property. This is a place where you can write that in there, that this additional outlot B is included. Paragraph 2 just lets you know that it's going to be DC or Montgomery County. This is where it becomes hard to use this form outside of DC or Montgomery County. Paragraph 3, this is your pricing and financing. So the way they set it up is they've done percentages, which I like a lot, because typically the percentages don't change. It's the dollar amounts that do. So there's not a lot of changes that have to be made when there is countering back and forth in a contract. So down payment amount, right? Buyer's getting, let's say, 80-20 financing. So A would be 20%, B would be 80%. Total financing would be the total of 1, 2, and 3. So let's say it's just 80-20, it's just 80% financing. Sales price is what you write in. So now if you are countering, the only thing you'd need to do is counter the price. You wouldn't necessarily, unless your financing does radically change, typically it'd just be the dollar amount. If there is something where you do need to put in like a dollar figure, you can always do that. You just cross out the percentages. C, first deed of trust. This is where you check stuff. And we've been asked, getting this question a lot, right? Like, are you guys gotten in a situation waiving financing? Okay.
The first one is the
Yep. So sometimes people are waiving financing, but they're still getting a loan, right? So what a lot of agents are doing is C, and then this contract is not contingent on financing. And then writing that buyer reserves the right to obtain a loan. Seller agrees to comply with lender requirements. Basically getting an appraiser in there, right? Because if you put in here, it's not contingent on financing, but your buyer's going to get a loan, you could run into an issue where the seller does not want to let your appraiser in there. And then you no longer can get your financing and now you're stuck. Make sense?
You do both.
You would not do both.
I mean, if
So if you're going to get so what is this says is there's an addenda attached. So if you're going to go and again, like hopefully this will end soon, but if you're not going to be contingent on financing, but you are getting a loan, you would only check this is not contingent on financing. You would want to write in something that says that the seller would allow you to get your appraiser in there. You would not check conventional financing as well, because all the terms of that conventional financing are going to contradict it being not contingent. Make sense?
And then you write that on all that extra pieces they're gonna go for it. That's on a general addendum.
You put it on a general addendum, or sometimes what I'll do is I'll write it in,
Just right
like,
here?
yeah, like using DocuSign or using DigiSign, you can use the text feature and then I'll write that in.
Okay.
Yep. All right, paragraph 4, deposits. GCAR gives you this option of deposit amount shall be held by who's the escrow agent. So if the escrow agent is not a real estate broker, you will need the Maryland Land Title Association, the MLTA escrow form. It's a 2-pager that just sets up the rules for what happens with the escrow deposit. If it's being held by a broker, which is rarer and rarer these days, we still hold them, but a lot of brokers won't hold them. Then you'll just follow this paragraph. And that gives you the option of has delivered or will deliver the deposit within X number of days. It says if it's a Maryland property, it must be within 3 days. So Maryland law says that earnest money deposits are to be deposited as soon as possible, but no later than 7 days. Our company policy for years has been 5 days because it gives us 2 days to get the deposit into the bank. But I always tell agents, like, look, like If you're struggling to get a deposit, at the end of the day, once you cross that 7-day threshold, now the responsibility falls on your shoulders for the deposit. So even if the client's like, look, I got to work a double the next 48 hours, like I can't get you the deposit, like, and I know you're like, okay, well, you're good for it, right? If you don't let the listing agent know, now you become responsible for that deposit. We've had some situations where then the buyer's dad calls and says, well, we don't want to buy it anymore, we're backing out, you don't have the deposit, we're at day 9. Now all of a sudden you as the agent, you're responsible for it. So best thing to do is if you're crossing that 7-day threshold, let me know. I can have a conversation with you about it, but typically what you're gonna have to do is let the listing agent know we don't have the deposit right now. Once you've done that, you've exonerated yourself. You're no longer fully responsible. It's up to the listing agent if they want to void the contract or not. And I just warn you guys, the state takes this very seriously. We had an agent with a $35,000 fine for not depositing a deposit in time. Again, working with a client who had done this to multiple brokers and just was trying to track her down. She was a doctor, because she worked at a hospital. Well, I think she was a patient at the hospital, not really a doctor at the hospital. So it just created a major issue. We were able to negotiate that down, but the state wasn't going to let her off with nothing. So just be really wary of deposits, right? And make sure, because this is kind of our duty to the public. This is one of the few things that because we're the link between this contract and kind of its enforceability, and that deposit is our job. Okay. 5, funds due at settlement.
Hello, can I ask a question?
Yeah, go for it.
Yeah, so the way I do, even if I have a ratified contract, if the client doesn't give me the deposit, I don't usually like send it anywhere. I just keep it with me until I get the deposit, the check, and then I can deposit the check, and then I will send the document to Jamie and the vendor. But otherwise, I don't do it. And some of my clients, like those who live really far, I had one who lives at Indian Head. It's like 1 hour and 30 minutes from my house. The last time we met, and she told me that house, so you wanted to make an offer on that house. She gave me the check, so I deposited the check before even the house went under contract. So I don't know if it's good or if it's not good, but most of the time, if I don't have the EMD with me, I don't usually like to sign the contract. Even if I have the ratified contract, I'm not going to send it anywhere unless I have the EMD with me.
Yeah. So what she was saying is, you're not sending the contract until you have the check in hand. Correct? Deborah?
Yes.
Yeah. So, I mean, that's a really strong policy. I mean, I think that definitely prevents any issues. Sometimes it's just, if you're doing it all remotely, and again, during COVID, we found some clients, it was just, getting in front of them was sometimes a little difficult, but yeah, whatever you can do to get that deposit check is really, really helpful. 6, seller and buyer perform in accordance with terms of the contract settlement, contract settlement date on, and then you need to put a specific date in here. This, sometimes it'll be 30 days from the end of the, 30 days from some date. It becomes a little tough because sometimes then there's dates that now we got to go to another part. I'm a big fan of put a specific date in here. And I've always been told legally, sometimes if you have TBD, right, then you may not have an enforceable contract because it's not really off of a concrete term when you've got these fillable boxes. It comes up a lot in home for sale contingencies because you're just not sure when we come under contract, when we're going to get that. I still put some outside date in there just to put something in there. And then maybe have a conversation with the agent that, hey, we'll have to change this at some point. This also notifies who the settlement agent is. Right now, there's a big pressure. A lot of listing agents are, the seller prefers to have settlement at such and such. So that's something I always say, like, check out, get their fee sheets, because some of these settlement companies charge a tremendous amount. You know, it's like a fuel service fee now, right? Like, so find out what it is, what their fees are, before you agree. And it says in here, buyer agrees to get the contract to the settlement agent within 10 days of ratification. This is a really good point, because sometimes there are title issues that the seller has. The longer you wait, the more, you know, it just compresses the time. And we'll read later on in the contract, there are parts of this contract that kind of allow the seller, if there is a title issue, it allows the settlement date to automatically extend. Your client, your buyer client may have canceled their lease, may have made plans for moving, and because you didn't get the contract to the settlement company in a timely fashion, now your client's at risk. So always get that to them as soon as possible. All right, 7 is property condition. So seller will deliver the property at settlement vacant, free and clear of trash and debris, room clean, and in substantially the same physical condition deemed as of the date of offer, home inspection, or other. Okay, so a couple things here. Vacant, free and clear of trash and debris. You know, sometimes like I've had people, there's been like a log pile that's been a brush pile in the backyard, and I've had some buyers like argue that they wanted that removed. You know, these are like walkthrough issues can crop up. You know, it's good just to kind of have a sense of, you know, I've had sellers leave a bunch of ladders behind there that they never didn't want anymore, you know, just leave shit in the house that I've had to clean up. So those are things just to talk to your clients about and just be aware of, you know, looking in places. Attics are notorious for stuff just getting left. So when if you get a home inspection and you're doing one and someone looks in the attic, just make sure that, you know, note if there's a bunch of stuff up there, then, and just give the listing agent a heads up. Okay, so substantially the same physical condition deemed as a date of offer, date of home inspection, or other. So if you do date of offer, that means that the house would have to be delivered in that condition at the date of offer all the way to settlement. That's the best option if you're not doing an inspection, because that was the last time you were actually able to kind of really determine what the condition of the property is. In a normal world, the best option is date of home inspection, because you have a report, you know what the condition was. If the refrigerator worked on the date of home inspection, it better work at the date at closing. If it doesn't, the seller's still responsible. So they're responsible from that date that we determined condition all the way through settlement. Other would be settlement date or some other determined date, because that would be a case where, let's say you've got a shell property. The property is just, it's deteriorating as we speak. We know that the condition can get worse. So basically the seller will deliver it. The date of settlement is the date of is the condition that we're going to deliver it. So
If you do date of offer, and you noted that the refrigerator was working, and then you go to do a walkthrough and it's not, will they honor that? Because the home inspection proved it was working.
Yeah.
But the date of offer may not. Is that disputable? I mean, can you argue with them at that point, or is it just like, oh, let it go?
yeah, it's definitely, yeah, absolutely. Because then it gets into, well, it should have been disclosed that it wasn't working. If you knew it wasn't working, then it should have been disclosed. Some of
At
that,
the walkthrough.
well, and when you know, or prior to writing the offer, if there was,
So if it was working when you saw
Yeah.
the house, it was
Yeah,
working,
yeah.
when you did the walkthrough, it wasn't.
right, and in that case, yeah,
Just
if the seller agrees, well, if the seller agrees, sometimes what happens, though, seller says, well, that refrigerator has never worked, right? Like, yeah, you should have, you didn't, you know,
That
you
should have
didn't,
been disclosed.
yeah,
right?
you didn't open the refrigerator, you should have known that it wasn't working, it's been unplugged. So there are sometimes
Okay.
those disputes that happen. That's, again, this is
Okay.
why like home inspections are really nice, or even
Yeah.
walk and talks
Mhm.
are really nice to kind of get a sense of that stuff. All right. And then, so seller will have all utilities on at settlement unless otherwise agreed. Seller will have smoke detectors and carbon monoxide detectors installed and operational prior to settlement in accordance with requirements of the jurisdiction. So smoke detectors, carbon monoxide detectors, you can't contract around the law. So even if, let's say, the seller, this is a foreclosure, this is something that they're, they cross out this smoke detectors. They still, these are county law. You still have to have the smoke detectors, carbon monoxide detectors working. Buyer acknowledges, subject to seller's acceptance, contract is contingent on inspections, right? You check that it is or isn't contingent on inspections.
Question.
Mhm.
Back to the smoke detector and carbon monoxide, the condo that we're doing now doesn't have any carbon monoxide in it. It says it's exempt from the new law that came out. The new law is single family homes, townhomes, doesn't include condos. So are they required to put in carbon monoxide before settlement?
Is there gas fireplace? Is there like a gas?
There's
Is it
gas
gas?
stove.
It's gas.
Yeah.
I'm pretty sure condos are not exempt from the Montgomery County
Because the inspector said it wasn't a requirement.
for a condo.
Yeah. So he didn't know that really. I mean, if he made note, they may want to put one in, but it wasn't.
Anything that's got gas, anything that's got an attached garage or fossil fuel burning appliance or like HVAC needs to have a carbon monoxide detector in Montgomery County.
Okay.
Yeah, unless if you want to, I mean, ask the inspector what he's, because I haven't seen that condos have been exempt.
All right. Well, it was 1969, and I know that
Mhm.
he just didn't make an issue out of the carbon monoxide not being there.
Okay.
And
And
I
it's-
asked him if it was required. He said no, something about that law specified single family homes and townhomes.
Radon does. Radon is exempt in condos in Montgomery County, but I don't believe that carbon monoxide detectors are.
Okay.
All right, and then the last paragraph, buyer acknowledges that except as otherwise specified, including electrical, plumbing, appliances, heating, air conditioning equipment, properties conveyed in as is condition, as of the date specified above. All right, makes sense? And part of the reason why they did this, back in the old days, like 10 years ago, we used to have that heating, air conditioning, plumbing, electrical, and systems of the home must be in working condition at the time. And we had argument after argument over like the clock on the stove isn't working, right? And now you got to replace the stove because the clock isn't working, like dumb stuff like that. So that changed that everything's as is. And basically what it means is everything's negotiable, right? Buyer can ask for whatever, seller can say, absolutely not, I'm not required to do anything, except for stuff that is kind of jurisdictionally required from the state or county. And that's smoke detectors, carbon monoxide detectors at this point. All right, access to property. It's a pretty simple one. Seller's going to give access to the property.
You skipped the home inspection.
What's that?
You skipped the home inspection one.
You check the boxes.
Yeah, I did.
Okay.
Yeah, you have a box that it is or isn't contingent.
If it is, then you have to attach the,
Yep.
then you guys require the sky slope too. I think, the inspection notice.
Yep, and it can be, that could be a septic inspection, it can be a radon inspection, it can be addendum of clauses, right, for home inspection. Alrighty. So paragraph 11, will the buyer occupy or not occupy? This makes a difference in the county, I forget which one of the county taxes, but if it, for owner occupants in the county, there is a tax credit, a minor tax credit. It's about a $210 credit. That's why that paragraph is there. All right, 12, wood destroying insect inspection. So, and this is a little bit of a difference between, there is a difference between this and the MR version. So buyer's expense, except if it's VA, then the seller's expense may choose to do a wood destroying insect inspection of the property by a licensed control firm. If they elect to do so, buyer will furnish a written report from a licensed pest firm showing that all dwellings and or garages within the property. So all dwellings, so this could be, you could have a 5-acre property, you have a garage that is at the back corner of the property, it's involved in this property. That's where, as a listing agent, you just want to make sure that you exclude certain things if you are going to exclude them. Garages within the property are free of evidence. I'm sorry, free of visible evidence of any live WDI, wood destroying insects. And this is live is the big thing. So in the old days, like 2 years ago, all the inspection firms would they would talk about brace, I think it's called, which is like the bodies, like dead bodies of termites. If they found those, they would say, we're flagging it, you have to treat it. Now it has to be live. Any treatments for live, and free from visible WDI damage. This is a tricky one because you may not have to treat, but if there is damage that was caused by WDI, the seller is still responsible for fixing that. So they may not find, bees, carpenter bees, but if they find the holes, seller is responsible for filling the holes in. It's dumb as all get out, but it's one of those things. And that might be, and I talk to people about this, like WDI inspections, about $35-40. It may make sense for a seller to go ahead and have one done ahead of time and just make sure that there aren't any gotcha moments. Because this is one of the few places that the seller is required to fix these items. There is no negotiation. So if there is a ton of WDI damage, seller's on the hook to do it. No ifs, ands, or buts. Just to kind of give you a little bit of balance, MR side, there is a cap. There's a 1% cap. All right. Any questions on that? All right. 13, this just gets into your lead-based paint regulations. The second paragraph is this lead renovation repair painting rules above paragraph 14. Basically, real estate agents were recommending their clients just go hire whomever over at 7-Eleven and have them paint your house. And what they're finding is they weren't following the lead rules. So they've kind of put the onus back on us that it's illegal for us to recommend non-EPA certified painters. So your painter should be, if they're doing any properties built 1978 or older, they need to be EPA certified. All right, 14, financing application. So this starts getting a little tricky, and there's some really hidden kind of important parts of this. So contracts contingent on financing. Buyer will make a written application for specific financing and any lender required property insurance, see capital L for lender, no later than 7 days after the date of ratification. So there's a 7-day period that your buyer must make written application. And this is important because there's also, when you get to the finance clause, the buyer can actually switch lenders during that 7-day period, which is kind of a tricky thing, because what happens is, let's say some listing agent takes your offer because, I know your lender Ron at Sandy Spring Bank. Your buyer wants to switch to Rocket Mortgage, same loan program, same 80/20 financing, same program, but they switch to Rocket Mortgage during those 7 days. It will piss off a listing agent, but you have the right to do it. I do tell agents, you need to notify them within that 7-day period so that they know this was done.
What does it mean by will make written application?
So they actually have to, in today's world, you actually have to have a ratified contract to be able to make formal written application. So you can get pre-approved and all that, but until you have a contract, technically can't give you they need to give you a written application at that point. Lender. Yeah. The other thing is this property insurance. So I talked, interesting, Maria was here. So I always have my clients hey, look, for 7 days, go file for your property insurance. Number one, go get a clue report right from them. It's a good idea. It'll help us with the home inspection. It'll help us see if there's any hidden problems with the property. Secondly, we ran into this problem. It's not as much of a big issue right now, but flood insurance. There are some properties that have flood insurance. And the flood insurance premiums on some properties are massive, where your buyer will not qualify. If your buyer doesn't apply for home insurance until after that 7-day period, and it turns out, like, let's say their payment like goes up by 1/3 because of this flood insurance, and they can't qualify, too bad. They potentially have, you know, lost their right to back out because they didn't apply for that property insurance. If they apply for it within the 7 days, they've done their job. Make sense? Yes, no?
So I didn't know that. So if they go to, you're saying if they get the insurance and the clue report and all, the buyer gets all that before the 7 days is up,
They just have to make application.
just make application
Yep.
for all of that.
Yeah,
And
the
what
clue-
happens if they don't do
So
that?
if they don't, and let's say there is something in the property insurance that, let's say, makes it really hard for them to qualify or makes it impossible for them to qualify,
For
financing,
the finance.
right? Because,
Oh, because it
let's
would
say-
just
yeah.
take up too much of their income. I see.
correct,
So then in that 7 days, if they find out the insurance is too much money, then they can just say, I'm out of here because I can't afford this house.
Yeah,
Okay.
exactly.
Okay, thank
As a listing agent, if you came to me and said, hey, look, my buyer can't qualify anymore because they found out that, you know, their property insurance is gonna be too much, I'm gonna ask, when did they apply? I don't know, right? Like, that's an important part.
Okay.
Because if they didn't apply within that 7-day period, and that's just, it's kind of a gotcha moment, and you just want to understand where those gotcha moments are.
Okay,
Yeah.
and then is it our responsibility to know about it needing the flood insurance, or is that something the insurance company? knows
Insurance company, yeah.
Because of the property.
And those change, you know, so, and they've done a better job. There was a period there where after Hurricane Sandy, where they were redoing all these flood maps, and FEMA like literally almost went bankrupt. You know, that they really pushed hard to redo these maps and make up some of the flood insurance money again.
Okay.
So,
So in addition to getting the home inspection done within 6 days, condo docs done in 7 days, you also have to do the insurance within 7 days.
Yep.
Okay, I didn't know that.
yep, application,
I didn't
yep.
know that either.
And again, this just talks about seller agrees to comply with reasonable lender requirements except as otherwise provided, and then the lender required repairs. 15, damage or loss. Just basically the seller is going to keep the property insured, and basically, so the risk of damage or loss of the property by fire, act of God, or other casualty remains with the seller until the execution and delivery of the deed of conveyance to buyer at settlement. 16, title report. So one of the things is, okay, settlement may be delayed for up to 10 business days to obtain the title report and survey, after which date this contract, after which date this contract at the option of the seller may be declared void and the deposit may be refunded in full back to the buyer. So the contract can automatically be delayed 10 days without the buyer having to agree or the seller having to agree. But usually what happens is it's the buyer is the one who winds up getting pinched by this because they've got the stuff on the moving truck. They've got everything loaded up and ready to go. So that's why, going back, it's really important to get that contract to the title company as soon as possible. Because if there is a problem, give them time to resolve it. The other part is,
Sorry.
uh-huh.
I'm going through a situation right now. It's my client fault. So we were supposed to close on the 8th, but my client was really slow in sending the documents to the lender to pay the appraisal, and we are extremely late. And yesterday, the lender told me that they couldn't approve the loan because my client was working 40 hours and then he stopped. Now he's working 25 hours, and we didn't know. So the underwriter told us yesterday that they can't approve that loan because it's working less hour now. And don't know. So I talked to the lender if we could get like a denial letter or something. I just don't know. I don't know. Now I'm feeling so stressed because and the listing agent keep calling. Are we closing? Are we doing this? And so I don't I don't know, and I didn't send any. So I spoke with the lender today. My client, they are looking for the wife's sister to apply so they can have enough income to qualify for their house.
Okay.
But so far we haven't done it yet. We are trying to talk to the sister, which she doesn't really want to do it. She wants to talk to her husband. So I don't know, do I have to send an extension order to the listing agent? What do I do? Like what now?
Yeah, I mean, I would ask for an extension of settlement because that's going to be finance related. I would ask for an extension. I mean, they could say, that they, the buyer failed to get information to the lender. I mean, I always tell people 3 ways to get out of contracts typically: home inspection, HOA condo, and then financing. Home inspection is usually the easiest because I send you a list, you send me a list back. I send you another list, you send me a list back. Now I don't want to sell you the house anymore because you're such a jerk. You don't want to buy my crappy house, right? Like we amicably part. HOA condo, it's the law. Most sellers understand that they just can't hold up. But financing gets really tricky because sellers do not like to, because it's completely out of their control. They had no say in this, and it's usually the buyer who picked the lender. The buyer failed to do something or didn't disclose something. So I would try to negotiate as an extension if you can,
Okay.
but just realize it's really hard to get out of a contract on financing. It's not impossible, it's just hard to get out with your deposit right away.
Yeah. Wow. Okay. Thank you.
Yep. So the next part is if there is a title defect, if the title, so title is to be good, of record, marketable, and insurable by a licensed title insurance company with no additional risk of premiums. Title may be subject to easements, covenants, conditions, and restrictions of record in existence, right? That's like sometimes you have a utility easement on the property. If as determined by settlement agent, title is not in the required condition, right? And this is a R, capital C, and they've already defined what that is. By settlement date, said date shall automatically be extended by 30 days. And seller shall promptly take all action necessary to place title in the required condition. This happens sometimes where you have an unreleased lien. Let's say the seller took a private lien. It was held by some attorney. That attorney's retired. He's moved to Florida. She's passed away. There's things that it takes some time to clear these things up. The property cannot be conveyed until we know that lien's been released. Again, this gets back to get your stuff to your title company as soon as possible. All righty. 17 possession date, unless otherwise agreed to in writing between seller and buyer. Seller will get possession of the property at the settlement date. Deliver any keys, fobs, and codes. This sounds simple, right, to us, but this is something, if you're working on the listing side, always talk to your clients about, just to make sure they know, like, because I've had some like, oh, we'll settle and then we'll move our stuff out, right? Like, once I know the money's there, then I'll give them the house, right? But I'm not doing it, and you don't find that out until like 2 days before settlement. So just make sure you have those conversations. Like, I give a checklist to my clients and talk about, when's moving date, right? Like, and I just want to make sure that they're conveying back to me when they know that they have to move out.
Per the other paragraph. Vacant. It's the house is delivered vacant. And
Yep.
free,
You got it.
whatever.
Yep. All right. And it talks a little bit about this. There are, if you're buying a house that has a tenant in it, right? Be careful, make sure you understand, like, and I would ask for a copy of that lease to make sure I know how, has the seller, because that tenant is going to be your tenant. If the seller didn't do everything correctly, because that could be a holdover tenant. The seller didn't give proper notices. So you just want to go and make sure that you know what you're walking into if there is a tenant in there. Make sense?
And just so I had a question about that. I saw a listing on MLS. They were saying that the tenant will move out, I think, at the end of November.
Uh-huh.
So how is that possible? Because I know maybe because of my client, most of my clients they use FHA, and based on the law, they can now they must live inside the house. They must move in before 60 days. So how can someone buy a house with a tenant and the tenant is living like
Yep.
4 or 5 months? How is that possible? If you are a cash buyer or
Yeah. Typically, it's going to be a cash buyer, an investor. And we've had some situations where depending on how long that period is, in this case, that's really long, that would be a cash buyer buying it more as an investment. And some investors would love to buy a property with cash flow positive day one, right? That may be a positive for them. But again, this is where if you are going into those situations, you want to copy that lease to understand what the terms are in it. You know, who's holding the deposit, you know, how much is the deposit, because the new owner is going to be responsible for all the terms of that lease now, turning over the deposit with the proper interest that's required by law. So, yeah.
thank you.
Yep, you're welcome. All right. We will skip. Okay, 20 adjustments. So everything gets prorated in the adjustments, from condo fees to sewer charges, taxes, connection charges. So just keep that in mind. Any fuels that are on the property stay with the property. That's the only thing we don't kind of divide up. All right, top of page 5. Legal expenses, basically it is a loser pays. So if you bring a dispute about and you weren't, you know, and you found that you were, you're wrong on, you know, you pay the other side's legal fees. In the real world, rarely does that happen, but this is more of a kind of a legal threat to kind of prevent frivolous lawsuits. All right, 25, this gets into default, what happens in default. So we run into this kind of lands in my chair a lot of times when we have a case where seller feels that the buyer is in default, right? The buyer wants to back out for financing, for instance, but the seller feels like, well, the buyer failed to do something they were supposed to do. So this is one where, you know, if the seller has failed to release the buyer's deposit in a timely fashion, and they were supposed to, then they could be charged any fees from the buyer for releasing that, you know, for getting that deposit released if they had to take a court action against the seller. You know, so when you do have a situation where contracts falling apart, like for instance with financing, you want to have a denial letter along with a release agreement. You know, and again, the easiest one is the home inspection, right? Because usually you all have agreed you're just not going to sell it to them and they're not going to buy it. HOA docs. So sometimes what happens is your buyer wants to get out on HOA docs, but they haven't gotten the HOA docs yet.
Yeah.
You know, it's just that was their only contingency. That's, you know, something happened. I always tell people that it sucks to do it this way, but this is the best way to do it. Is I call the listing agent and tell them, hey, look, something, you know, my buyer's going to back out once they get the HOA docs. 2 ways we can handle this. Number one, you send me a release. Use the listing agent, send me a release tonight, you know, and I'll get my buyer to sign it, and you get the house back, you get it on the market, you get it resold. Number two, we just wait till we get the HOA docs, right? And then she's going to cancel it at that point. And what happens is they will cuss you out and they'll hang up on you. 10 minutes later, they will call you back. And they'll say, okay, tell me more, right? And basically they get it, right? They'll send you a release. Because what you don't want to do, if you don't have the right to send a release, you don't want to send a release for opting out on the condo HOA docs.
You
don't have them. You technically violated the contract. So that's why that phone call to the listing agent is what I do.
Joe, doing that is not dangerous. That is the listing agent cannot use against you, like against the buyer agent, like saying this is not true. They are lying. The truth is not the HOA dog. The truth is maybe they found a better option or something. No.
Well, then just we'll wait. Just send us, yeah, once we get the docs, then we'll review the docs. Yeah, I mean, I put it in the listing agent. It's their decision. How they want to handle that.
And so my point is, if you do that, can the listing agent, I don't know, sue you or complain against you by saying, it's just using this against me, but he called me earlier. I don't know, I have a text message or I record the message or something. They have other reasons than the HOA. No.
Yeah, I mean, they could, but again, that's why I do it as a phone call, not as a written email. And I'm just gonna, I'm gonna leave it. I'm not gonna give them a whole lot of details. Like, yeah, they found another property. I'm not giving them fuel for their fire. I'm just telling them, look, once my client gets HOA docs, right? Because again, there could be something in those HOA docs. It becomes I try to leave a lot of details out as far as why. And you're right. I mean, I don't want to give them like, yeah, like she's, he or she's done something and isn't going to qualify. So, okay. All right. Getting on to page 6. Um, 27, this happens sometimes, assignability, where sometimes some foreclosures wind up having some assignability. Someone bought the house at foreclosure, they don't own the house, and to avoid paying taxes twice, they want to assign the contract to another party or just assign the contract over to your buyer for a fee. So this contract may not be assigned without the consent of both the buyer and seller. Buyer and seller agree in writing to an assignment of this contract. The original parties remain obligated hereunder until settlement. This is always something like, if you do run into one of these situations, feel free to reach out to me or reach out to the settlement company, because this is something that it may, or depending on your loan and your financing, FHA sometimes will not allow assignability of contracts. So it may not be possible.
When that happens, like if a wholesaler or somebody buys, if you're in a situation, will they put it on MLS again? In that, because it's, I don't know.
Yeah, because there are some people who, cash buyer can, sure, if they're fine with assignability. Yeah. Again, it's, some of these deals are just trying to avoid transfer and recordation tax, and I'd much rather a cleaner transaction, and it gets into what kind of title can be delivered, because sometimes you may not be able to get a fully marketable title. You might get an insured title, but not a marketable title. So there may be defects in the title work that sometimes when you buy, because sometimes what happens is you buy from a foreclosure. Let's say there's somebody who does a lot of foreclosures. They work with a foreclosure attorney. And they give you like, oh, they'll do the settlement for $100, right? There's a discount for it. Typically what's happening though is you're not going to get a full title. If you went to like Home Settlement Center, where they would make sure that you're going to get a fully insured, because if you went and sold it, if you went to go sell it the next day, went to HSC, you could sell it the next day. If you're buying it from one of these settlement attorneys who does foreclosures, it could have a defect that you have to clear up now.
Okay.
No, so just something to keep in mind when you are looking at foreclosure stuff. 29, definitions. Days mean calendar days. Business days, which is rarely ever used, is Monday through Friday. In GCAR world, the day ends at 5:59. Actually, I'm sorry, ends at 6 o'clock. So that's when you're coming to the end of your contingency periods, that's just something to keep in mind too. If settlement date falls, like let's say you just weren't looking at your calendar, you just pick a lucky number for settlement date. If it falls on a Saturday, Sunday, or legal holiday, then the settlement will be on the prior business day. Date of ratification. This is one where we sometimes come into issues. This contract shall be deemed ratified when the contract and all addendum and all modifications therein have been signed, initialed, where required by all parties and delivered to the other party pursuant to the notices paragraph. So date of ratification, just because I put 4/6 on the date of ratification, that's not necessarily means that that's the date of ratification, right? Because if there's still something lingering, we could still not be ratified. So that's where I always like, if I'm the last one ratifying it, sending it to that party, I'm always like, hey, just want to make sure you have today 4/6 as the date of ratification.
I had someone try to sneak in an early date on me on the condo delivery docs. She
Mhm.
put down like the day before, even though we didn't get them until the following day, and I marked through it and changed the date.
Yep, good. Yeah, and it's good to have those conversations early. And again, I always like to have them like, look, like if I'm gonna have a problem, I want them on day 1, not on day 6 or 7, depending on whose definition it is of 6 or 7. 30 notices and notice.
Sorry, John, I have a question. So if all the parties agree and sign and they didn't, I don't know, for some reason, they didn't put the date of the ratification, is the contract ratified or not?
Yep,
And
yep, it can still be ratified without a date of ratification. It's just up for
Okay.
interpretation potentially. And
Mhm.
that's why I always want to put one in there and confirm with the other party that that's what I think it is.
Okay, so that date, is it required for the listing agent to put the date, or the buyer agent can,
It's
the buyer agent can also put the date?
yeah, and it's typically the last party, right? Like if I'm signing off last and delivering the contract fully initialed, then I'm going to put the date of ratification in.
Oh, okay, good to know, thank you.
Yeah, you're welcome. So notices and delivery. So notices means a unilateral communication from one party to the other. So a notice is something that you don't necessarily need agreement on. And GCAR has a nice notices addendum that is, there's only one signature spot, right? Because that could be like, we are voiding the contract based off of this. I don't need the seller to agree with it. I can unilaterally, as long as I believe I have the right to do so, I can just tell you we're doing this based on a right that we have in the contract. Delivery. So delivery means by wire or electronic medium, which produces a tangible record of transmission, fax, email, hand carried, sent overnight. And it includes an attachment of the actual copy of the executed instrument being transmitted. So I can't just say like, oh, here's the sellers say they want 550, right? That's not considered a notice, right? It would have to be actually the sellers wrote, sellers hereby want 550, sign it, right? That's what you can deliver. Just you writing an email isn't necessarily email delivery. They also allow overnight or delivery by postal service. In the event it is postal service, it's deemed to have been made the next business day following the sending. I hate that though. I hate putting stuff in the mail, but it happens. So resale packages may be delivered. This is the top of page 7. May be delivered by seller or seller's agent through an electronic link provided by the management association. All right. And delivery may be made to buyer or buyer's agents in the contract or to that agent's supervising manager. So I can accept delivery for you. Okay. Any questions? All right, so that's kind of a breakdown of the MR. Let's, GCAR, I'm sorry. Thank you. Give me 1 second, I'm gonna grab some more water.
Sunshine.
Yeah, I know, I'm beginning to feel
Hi,
really
Scott.
sleepy. I didn't eat as much because I find that these lunches are so good.
You're gonna have to
About
watch the
halfway
recording
through.
for the key card.
That's how I feel now, I'm like.
I'm ready for a nap. Was it the turkey? I shouldn't have gotten the turkey.
I drank this nice big coffee.
I know, I call it like.
All right, I know this is boring.
It's not.
No,
boring.
Not
We're
you.
blaming the
It's like
food.
sunshine is here.
Yeah,
And the food.
yeah.
Perfect for napping.
We're very comfortable.
All right, so I gave you guys a cheat sheet too. So this is, it's a little older, but it still makes sense. So when you line up the two contracts side by side. So I'll kind of dig into MR. All right, so MR, top of the box page says time is of the essence, just means that, and this is kind of a legal reason why this is in here. You know, the dates mean the dates, the time mean the time. Typically in a legal document, there is some leeway that they give, right? If it's give or take, but in here, time is of the essence means specifically that there are performance standards in this. Paragraph 4, property. Again, you're a little limited in how you describe the property. That's the reason why the GCAR version allows you a little more flexibility. 5, being conveyed, fee simple or subject to a ground rent. A lot of ground rents in Baltimore. So those are something to really make sure you're aware of. Because you'll see difference in prices in properties. You're like, wow, this looks like a good deal. Well, it may have a ground rent attached to it. Purchase price. And then 7 is payment terms of a deposit. So initial deposit made in the amount of, and then an additional deposit. I do like the way they have this because you can actually do it that, let's say you have a situation where you're going into an inspection, you know, you want to give a small deposit and then after the inspection period, you'll give a bigger deposit, right? So this allows you to do a small initial deposit and then once we clear a contingency, a larger deposit. All deposits be held in escrow by, and then if it's not being held by a Maryland broker, we need to have that MLTA form. And then interest bearing or non-interest bearing account. Please do not ever put anything in an interest bearing account. It actually costs your clients more because we have to set up an interest bearing account if we're doing it. And your client will not get enough interest to pay for the fee to set the account up. So it's a pain in the butt.
Why would people do that anyways?
Rich people problems, right? Like,
Oh, I thought
Well-
that wasn't even an option. I felt like it had to be non-interest bearing
Yeah.
account.
you know, I'm giving you a $100,000 deposit, right? Like, I don't want to take my money out of my, you know, my investment account. It's not going to earn any value and give it to you. So I want interest on that. What they don't realize is that it's like $5 interest and it costs $25 to set up an account. So, and unless you were going to hold it for like 5 years, it may make sense. So it just doesn't make sense. Date of settlement, right? I do like that MR puts the date of settlement, sales price all on the same page. GCAR's got the settlement date on the second page. So you got your settlement date here. Financing, they give you your financing options. But again, some of the differences, and this is where I'll give you a warning. If you are using let's see here. If you're using the GCAR contract, do not ever use the MR financing with the GCAR contract. Some of that is because the MR financing paragraph doesn't have certain information that the G car does, because you'll find in here, there's a lot more financing, but there's different financing information in the MR contract than there is in the G car. So sometimes when it comes to mixing forms together, that's like the ammonia and what causes mustard gas. What is it? Ammonia and vinegar or something, right? Yeah, like it's just things you think are innocuous wouldn't make a chemical reaction. Same with this. So, and again, I'm going back. If you're using G-car contract, do not use MR financing addendum. You can use a G-car financing addendum with the MR contract, but it doesn't work great, but it will work-ish. Okay. 10, financing application and commitment. Buyer agrees to make written application within. You got your days here to put for your application. MR is not as specific about when the insurance has to be made as well. And then if written commitment is not obtained within X number of days from the date of acceptance, seller at seller's election may, by written notice, the buyer declare the contract null and void. Or B, buyer upon written notice, the seller may include written evidence of buyer's inability to obtain financing and declare the contract null and void. In either case, the deposit shall be dispersed in accordance with the deposit paragraph. If buyer has complied with all the obligations under this contract, including with respect to financing, so it talks a little bit about the release, the buyer will get their deposit back. So what happens here with the commitment, if the buyer hasn't gotten their commitment in 30 days, the contingency will continue on until the seller calls it quits. Number 11 is alternative financing. So G-car world, you can go to alternative financing and completely switch horses. In MR world, you have to carry both horses with you. So if you decide you were going FHA on the MR contract and your buyer decides we want to try conventional financing for alternative, you have to continue down the path with your FHA and your conventional. So it says here, provided buyer timely and diligently pursues the financing described in the financing paragraph, the finance commitment paragraph, and the buyer's responsibility paragraph, buyers at buyer's election may also apply for alternative financing. So they still have to keep whatever financing they originally applied for in motion. It can't just stop. So that's just a little nuance. And again, it allows them to go pursue other financing, but it's not contingent on that financing. They're still going to be held to the first one. Home inspection and or environmental inspections. Basically, the buyer has the right to have inspections and they have to check if they've got addendum attached or not. 13, this is inclusions. So it's my pet peeve. I hate this part about MR. Apologize for those who love it. What happens is the sellers fill out a inclusions exclusions form, but it's really clear the seller, like the buyer, cannot ratify that form. You have to take all those check boxes and put them on here. Mistakes happen all the time. So just be really cautious. As a buyer's agent, make sure you're transferring it correctly. As a listing agent, make sure you're reviewing this correctly, that the buyer transferred things correctly from your form onto this form. Make sense? 14, agriculturally assessed properties. So there are agriculturally assessed properties. Typically, this is going to be your land deals. But if a property was being used for ag, there's an ag tax, and that ag tax has to be paid. So what happens is the seller, because they were using an ag, they've got a lower tax base. Once property sells, they're put in a stepped up tax, and there's a tax that needs to be paid. It's usually a really large sum. So just something to, typically the seller's the one who got the benefit of that tax. So typically the seller pays that. Same thing with the conservation and management program. The seller typically got that credit. So they typically pay that. Again, paragraph 16 is identical to pretty much what was in G-car for lead. C, Maryland has this special lead poisoning prevention program. Again, you're gonna have lead forms with it. 17 is the deferred water and sewer assessments. So this is a lot of new subdivisions. What was happening in the olden days, we used to have this front foot benefit charge to show up on your tax bill. But what happened was people were writing off that front foot benefit charge because it was within the property taxes. Technically, it's a utility, not a tax. It's not tax-free. So they've now, all of the neighborhoods that have been built in the last like 14 years, the HOA creates a private utility company, right? And that's where your front foot benefit charges. So every January, the seller gets a $300 to $1,400 bill that needs to be paid. This is that what was happening in so many cases. The seller's like, I don't know, it's one time a year, I forgot about it, and now the buyer has to pay this. So this really puts the onus on the seller to disclose this. If they don't disclose it, then they're responsible for the remainder of the front foot benefit charge. Make sense?
So it's the same thing as a front foot.
Yep.
Front foot, yeah.
19 is our wood destroying insects. This is a little nuanced difference between GCAR and MR. Same thing about VA. VA does not pay for the inspection. So careful visual inspection that there are no evidence of termite or other wood destroying insect infestation. The residents within 3 feet of the residence, which is nice because that limits the scope of how far out they will go, as opposed to GCAR, which could be 300 feet. Garage, other attached outbuildings located within 3 feet of the residence, and a maximum of 10 linear feet of fence. If there is evidence of present infestation, so this is the difference between live and present infestation. I wish they just put live in here, but it's present. It can be argued that present could mean dead insect, casing. I tend to say that definition is live, but anyways, that creates a little bit of a gray area. And I'm sorry, and I told you guys 1%. It is a 2% cap on any damage and treatments that the seller. I've never seen a termite treatment or damage over 2%. So it's nice to have the protection, but I just haven't seen it ever called into effect.
2% of what? Of the purchase price.
All right, 20 gets into deposits. We talked about the deposit rules, right? 7 days is the maximum. Our office policy is no more than 5. And then top of page 5. So MR gives you a 14 additional days if there is a title. So again, going back to GCAR, there's a potential 10-day or a 30-day extension. GCAR has a 14-day extension if there is a title issue that needs to be resolved. The contract automatically gets extended. It's just something to, again, it's a worst case scenario. No one ever wants to call their buyer and tell them, hey, by the way, like seller can't settle. Well, we want them to pay, and it's like they have the right. So this is where you just want to, in a sense, warn them a little bit ahead of time. 22, conditional property. Again, delivers property vacant, clear, trash and debris, room clean, in substantially the same condition as of the date of contract acceptance. They've written in here contract acceptance. GCAR gives you the option of 3 different options. Buyer reserves the right to inspect the property 5 days prior to settlement. This is the buyer's walkthrough period. same time period in G car. So there's always a little bit of a debate. You know, you want to get, because a lot of settlement companies don't allow escrows, like you want to get in there early, that if we have a problem, we have a time to solve the problem prior to settlement. But you also like, I want to get in there at the last minute, because if the dishwasher breaks, I want it breaking like
You were
on the
there.
seller's time, not my time, right? And like you'd hate to walk in and seller's on their way to Oklahoma and you got to bust the dishwasher. So there's always a little bit of a debate with this. I always tend to settle like the night before or the morning of. I mean, sorry, walk through. Yeah, I've got good contractors. I feel confident that if I have a problem, I can get a number quickly if need be. But just keep in mind that's kind of where it is. As a listing agent, sometimes agents will ask me, well, they just want to come in and measure, right? Like, you know, we're within 5 days. I'm like, do you want this to be your walkthrough? Right? Because I just don't want buyers in the house all the, because it just, problems happen. All of a sudden, like, you know, they bring their mom and dad, and dad wants to slam all the doors and turn on stuff, and then like something gets left on, something isn't working the way it was working before. Now I thought I'm being the nice guy, now we got a problem, right? Like, I don't know, I just much rather be the bad guy in the beginning, but you know. 23 talks about adjustments, we talked about that. 25 is the first time home buyer. So you also have the Montgomery County Jurisdictional Addendum. The Montgomery County Jurisdictional Addendum adds this language in to make it comply with Maryland and Montgomery County. So the transfer and recordation taxes are split 50-50. If they are a first time home buyer, the way the rule was written was that the entire amount of the state recordation tax was paid by the seller. What they put in here is that it's expressly agreed that it'll be split 50-50. But what will happen is sometimes if you have a savvy buyer who's done their research, they'll say, hey, look, Joe, like the law says the seller pays 100% of this tax. Well, the way the contract reads is it is modified to be 50-50. That was the way the state made the state look like it was cheaper to buy in Maryland, because they, you know, they were saying the seller was going to pay all the taxes. It wasn't that the taxes are any cheaper, it was just the buyer wouldn't have to pay anything. But in the normal world, we negotiated that it's 50-50 regardless. All right, we'll skip to 32. You've got, this just lays out that this is not contingent on in any manner of settlement, sale, or lease of any other real estate, right? And we always want, like in our lender's letters, to say that if that's the case. But it does say in here that if you are going to be contingent on any of those things, you need to have some type of external contingency. Leases, seller may not negotiate any new leases nor renew existing leases for property which extend beyond settlement date or possession date without buyer's written consent. Um, 34 default. So one of the differences in here is MR contract requires mediation. So if there is a dispute that arises, mediation is required. And then it goes into arbitration. G card does not have that same requirement. And so what I tell folks, so what happens is with these, you know, when there is a deposit dispute, really it starts becoming into the business decision. Because if you're required to go, and if you're using the MR contract, you're required to go to mediation, which is about $650. If you can't resolve it in non-binding mediation, then you go to an interpleader or arbitration, where $500 gets taken out. So off the bat, like, we can't come to a decision here, it's gonna be about 1,100 to 1,200 bucks. And that's not including any attorney's fees or anything like that. So out of that $3,000 deposit, almost half is already gone, right? So why instead of paying a mediator and an attorney, like, let's try to resolve this thing, right? And it sucks, you deserve your $3,000 back. Seller feels strongly and adamantly they're not giving it back to you, like, let's give them 500 and be done with them, right? So sometimes we try to find solutions to these deposit issues, because the seller, in all honesty, a lot of sellers, like, they're just gonna hold your deposit. They're just not gonna release it, right? The buyer wants it back. So the only way that they can get it back is if they start spending money to get it back. And yes, it says in here that it turns out that the seller should have given it back in a timely fashion. They didn't. You can go sue them for that amount. Like, good luck, right? You're gonna spend a lot more money trying to sue them. And I'll tell you, most judges don't like awarding attorney's fees because they assume a lot of times, like, your attorney fee was, let's say, $500 an hour. Well, that could have been 150, or that could have, right? Like, it's not as cut and dry as this. So sometimes we just try to encourage people to negotiate this thing out. And I always tell people, like, my famous line, I guess, like my least favorite, but famous line is, like, look, we're really good at bringing contracts together. We're terrible at pulling them apart. So when our clients do want to back out of a contract, cancel a contract, like, they tend to need to get some legal advice, right? Like, I can help you through this, but at some point, like, I just don't know what's going to happen. I don't know if the seller is going to come and sue you for more than the deposit. I don't know if the buyer is going to come and sue the seller because the seller didn't release the deposit. I just can't tell you what's going to happen. So that's where sometimes you need some legal advice. In 35, this talks about that mediation. 36, same thing with the attorney's fees. It is a loser pays. We will skip to 42. They get into the flood insurance, right? They go really in depth into the flood maps, like we were talking about. This is why it's always good. Get your clients with a reputable insurance company as quickly as possible. Uh, 52 is something that G-Car contract doesn't have. So this talks about the criminal activity and sex offenders list. Always good to have your clients check that out themselves. You don't want to be the one who's transferring that information to them.
That wasn't in G-Car.
Yeah, it was not. And again, non-assignability. The MR contract goes all the way to midnight. G-Car contract ends at 6 p.m. That's it. That's kind of in a nutshell. And again, this form is really helpful because this will line up a lot of those differences side by side. Give you some ideas. All right, any questions about this?
You do know with the Maryland non-resident salary withholding tax is.
Oh,
these
good one.
days?
Yeah. So it is, I believe it's 8% now.
8.
Yeah, thank you for bringing that up. So if you have and again, on the listing side, you have a seller who lives in Tennessee selling their investment property here in Maryland. There is a non-resident withholding tax. What was happening in the olden days was people would sell properties. They'd be a non-Maryland resident. They owe Maryland capital gains tax on that property. Person was in Florida. They're like, screw you. Like, I'm not ever coming back to Maryland. Like, you don't have any jurisdiction to take my money. So Maryland requires now that some attorneys cannot disperse until they have either a waiver of that fee or the fee paid, or they have to take the withholding amount. It is I've never seen it more. I've never seen it 8%. It's a huge amount that they take. And what if your client wants to, your client can go apply to the state of Maryland. They need about 21 days. They can apply to the state of Maryland and get that actual tax amount, put in writing to the settlement attorney, pay that, what that amount is. And that's sometimes usually around like 1% or less, depending on when they bought the property. But that is something, if you are dealing with an out-of-state seller, get them with the settlement attorney right away to kind of figure out the non-resident withholding. Any questions? All right, you guys feel dangerous enough to go write a bunch of contracts?
Yeah. Cause trouble. You're there to
Yeah.
back us up, right?
Yeah, absolutely. And again, that's one of the things, like, if you ever have a question, like, please feel free to call me. Like, I do this stuff all day long and I love it. I do. I like going through the stuff, just figuring out strategies. You know, so, and again, the devil's in the details. There's these little things here and there. And I find that sometimes when mistakes happen, it's just people haven't read it thoroughly enough and understand. Or what happens is a rule change, right? Someone's been in the business 25 years and it used to be this way. So I literally, yeah, I've got to open up my book
That's what I
and
thought it was.
read it to them. Yeah. So, cool. Thank you, guys.
Thank you.
Thanks, Jeff.